Can everybody see the screen? Can you guys see the screen? Okay.
It's still
Not yet.
not yet. It's still loading.
How about now?
Yes.
Okay. Oh, I think we've got everybody in. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation. My name is Nia Murray, and I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. And we're here today to talk about how to create your own will and transfer on death deed. Included in our partnership, we have presenting today with Lone Star Legal Aid, Ms. Jessie Campbell, who's going to be facilitating and providing you all with the legal expertise and information that you need about your wills and your transfer on death deed. But also included in our partnership, we also have the City of Houston's Department of Neighborhoods. And joining us, we have Ms. Cecile Carlson. Included in the partnership as well is the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together, we all make up a month of service. And basically, what a month of service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information to the community relative to asset protection, asset building, community empowerment, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that potentially do not have access to a lot of information, don't know where to go for particular resources that are available to them for free or at a very low cost. So we wanted to collaborate and come together collectively so that we can try and create a larger impact, reach more people in the communities that we all serve. And we've been able to do that through this virtual platform because we have people that are joining us from all over the city of Houston, the Harris County, surrounding counties across the state of Texas, and even in some instances across the country that are joining us. And welcome back, Ms. Mack. Again, make sure that we try to get as much information and reach as many people as we possibly can. So that way we can try to help disseminate information, accurate information for people to have access to. We know that there's a lot of information that just kind of floats around that's general information that you see on Facebook and TikTok and Instagram and so on and so forth that's not relative so much to the state of Texas as opposed to other places. So again, we try to provide you guys with the expertise from those professionals in that area so that they can give you the most accurate and up-to-date information. Laws changes, processes change and things of that nature. So we want to make sure that you guys get the most accurate information as you possibly can. Do know that the information that is provided here today is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of any civil legal assistance. And Ms. Campbell will go over into a little bit more detail about other services that are available aside from wills and estate planning through Lone Star Legal Aid as well. Do know that you have the opportunity to ask whatever questions that is that you may have. Feel free to type your question into the chat or raise your hand and unmute yourself at the end of the presentation so that you can address Ms. Campbell directly. If you are joining us on Facebook or on YouTube, feel free to type your question into the comment section and we'll make sure that it gets read aloud at the end there as well. Do keep in mind that, again, we are recording this session as well as broadcasting on our live social media platforms. So we do ask that you try to keep your questions to be as general as possible so that your personal information does not get out there for everybody to have access to. So do keep that in mind. We do want to try to protect your privacy as much as we possibly can. So with that being said, there's a lot of information that's going to be covered here today. by no means do we expect you guys to be the experts by the time you leave here, but do know that you will be a little bit more informed, a little bit more empowered about how to create your own estate plan, what can potentially save you money from hiring an attorney, and so on and so forth. So let's, without further ado, we're going to go ahead and get started. So, Ms. Cecile, would you like to introduce yourself, and then we'll have Jessie introduce herself.
Sure thing. Thank you so much, Neo. Good afternoon, everybody. On behalf of the City of Houston and the Department of Neighborhoods, we want to thank everybody and welcome everybody to another information session here through the A Month of Service Partnership. And anytime Jessie is on camera or presenting, it's always such a treat because she is a wealth of knowledge. So definitely take advantage of this opportunity to get information, to ask questions. And I'm not going to take up any more time because I want to get right to it. So, Ms. Campbell, if you want to go ahead and introduce yourself.
All right. Thank you, everybody, for joining us today. First, let me start off by apologizing that I am not on camera today. I have had some technical difficulties, and while I was able to fix my mic problem, I was not able to fix my camera problem. So apologies for that. If you really want to see my face, there is a recording of the same presentation available on the AMOS YouTube channel. But welcome again. My name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and today I'm really excited to present on how to draft your own will and transfer on death deed. So this is a part 2 of a well, actually, let me go ahead and introduce Lone Star Legal Aid a little bit more. I am with Lone Star Legal Aid, and we are a civil legal services provider. And what that means is that we provide assistance on civil matters that includes consumer, employment, family, healthcare, housing, landlord-tenant, neighborhood problems, juvenile issues, public education, benefits, estate planning, and probate. Those are the things I have listed on our slide. We serve 72 counties in the eastern and Gulf Coast region of Texas and 4 counties in southwest Arkansas. So think of the eastern third of the state of Texas from the Gulf to Arkansas, and that is what we cover. We have 14 offices, including our Houston headquarters, which is where I am located, along with the 13 other offices that you see listed there. We are a financially eligible base client, so that means that you do have to apply for services. We have to confirm you are eligible. It is unfortunately for us a little bit mathing involved, and so it's a little complicated. So I can't give you any direct numbers specifically on who's eligible and who's not eligible. It's based on the size of your household, your income, and the assets that household has. But I also like to always tell people, don't assume that you don't qualify for services from either us or other legal aid providers. The estimates have been as high as 30% of the state of Texas qualifies for services. And so I usually tell people, if you think you may be in that bubble or you think you may qualify, go ahead and apply. It's about 30 to 45 minutes of your time to do the application. You're in no worse position to know that you don't qualify for services. Now, obviously, though, if you're like a millionaire, you don't qualify. But just kind of keep that in mind as you go forward in needing services. Just as a reminder, as Ms. Nia said, this is for educational purposes only. None of this should substitute for legal advice. Anything that you have a specific question on, you should consult an attorney. That also means that don't ask those questions here. One, I can't answer. I'm not allowed to provide legal advice without confirming that you are eligible for my services. But also, this is not a private space. This is a very public space. For those of you on the Zoom, it may seem like it's just a Zoom, but we are recording this. It is airing live right now on some live feeds on social media, and the recording will be available for later viewing. And so we want to be sure that you're not sharing any private information in the context of this, because once it's on the internet, everyone's going to know, and we don't want you asking those questions. If you do ask questions, please keep that in mind, that you want to be sure that you're not sharing anything that's private as we go. All right. So let's talk about what we're going to be covering today. So this is our agenda for today. We're going to be talking about how you choose a representative for your documents, and then we are going to go specifically into a last will and testament, what the types of wills are, what a pro se document is, and then we're going to talk about completing the forms. We're also going to talk about how to complete your own transfer on death deed, and then a little bit we're going to cover the other advanced planning documents. This is part 2 of a dual presentations, if you will. So last month I did a presentation of a general overview of legal advance planning, what it is, why you need it, what all the different documents do, and in general what you need to know about when you're thinking about your advanced planning. If you haven't watched that video and this is your first presentation you're coming to us, I do recommend that after this presentation you go back and you watch that first video. It will probably answer a lot of those general questions as it relates to advanced planning, in terms of what the documents are and what you need and things along that line. The purpose of today's presentation is very much about drafting your own documents. It is about taking these Supreme Court approved forms and then doing it on your own. Now, one of the things that I do kind of like to talk about at this stage, which is, actually, no, we're going to talk about that in a little bit. So sorry, apologies for that. So let's continue on with our first topic, which is choosing your representative. For any of your documents, but of course today we are talking about your will, and so the concern is going to be on the will side of things. But for any of your advanced planning documents, you're going to be selecting a person who's going to be acting on your behalf. The titles are different depending on the document. In the will, it's your executor. That's what they are called. So the executor would be coming in and handling the estate. The estate is the document, it is what remains, right? It's all of the property and the debt, and then all of the steps that need to be taken to settle the estate during a probate administration. And so that is the role of the executor. They're going to be responsible for taking your will and putting into action and making sure what was said in the will happens. Who gets the house, who gets the debt paid, and they're going to be kind of handling that work. And so when you're thinking about that, like who that person is, right? Obviously it's someone that you know and trust, who's going to do what you want them to do, who's going to be working in the best interest of the estate and the beneficiaries as named in the estate, in the will, and what you would do, like if there's any things that's ambiguous and you're not sure, and you're not there, right, to answer the questions, and so then they would understand what they would want you to do. It's work, as I just kind of explained, right? The executor is going to be potentially selling a house if the house has to get sold. If the house is not being sold, then we'll be working with an attorney to draft deeds to transfer the home, and do what needs to be done there. We'll be contacting creditors if there's amounts owed, contacting the credit card companies and negotiating payments. We'll be doing, so it is work. So you got to think about a person who can handle that, and be able to do that work on your behalf. It is a little bit sometimes an emotional decision-making process, and you have to kind of talk to people about it, right? Because who would be the quote natural choice or the expected choice may not be the best choice, right? It's very common for people to come in and say, well, obviously it's going to be my spouse. It's obviously going to be the oldest child who is already starting to take on the mantle of becoming the leader of the family moving forward. And that might very well be true, maybe, but they also might not be, right? When I have couples who come in and they're elderly couples, they've been married for 50 years, well, your spouse might not be the best choice to serve as the executor. Spouse has just lost a life partner and someone that they care very deeply for, and they have to go through a grieving process depending on their age, depending on what the situation is. Do we really want spouse having to do all of the work, right? And similarly, an eldest child or any child may or may not be the best choice for that, right? And because maybe they're, it's like, well, no, I know I trust them with a lot of things. I trust them with my medical decisions. I know that they have my best interests at heart, but that person, I love them to death, but I've never seen them file a tax return on time, right? They've always filed those extensions, and there's going to be deadlines. There's going to be things you have to kind of do when you're doing that work. And so it's like, so instead I'm going to pick my cousin, Janie, who is an accountant and really good at handling paperwork and doing things along that lines, right? So you want to be kind of keeping that in mind when you're selecting a person. We don't recommend any shared authority. This is a person who is going to be going in and taking care of a lot of things. And one of the reasons why we are doing estate planning documents is that you want to be sure that there's no conflict. You want to be sure that, and anywhere, right, among the beneficiaries, but you also don't want any conflict among the executors as well or your representatives. You want someone who can be able to make a decision and move forward and not have a judge decide on behalf of the estate, according to the rules of the law, right? You want someone who can kind of do all that. Nothing against the judges; they're fantastic people, but they're strangers to the estate. They're strangers to the family. They're going to be coming in from a very legal perspective, as opposed to the personal perspective of making sure that the estate is handled in the way that the decedent, the person who passed, wanted it to happen. Obviously, you're going to want to discuss the decision with the person, so that way they are aware that they've been selected. Don't let a person be surprised that they're the executor, and you want to be sure that they understand that they're taking on this role. And you're going to also want to have an alternate and have the similar conversations with the alternate in the event that the original executor is unable to serve. I do highly encourage everyone to have alternates. It's pretty common that I have people who say, "Well, I don't really have somebody else. I don't really want to have an alternate." But the truth is that sometimes you do run into problems, and when you don't have a name alternate, it can create an extra level of complexity and difficulties for the beneficiaries to be able to get the will admitted and handled if it's not if there is no one else named to be able to do that. All right, so let's talk about the last will and testament. So, what does a will cover? And it's important to understand what the will covers because you have to kind of do different things for different pieces of property. So, the best way to kind of talk about it is kind of in the negative. The first thing is to kind of talk about what a will doesn't cover. Those are known as non-probate assets. And non-probate assets are property that is owned in such a way that the legislature, either in Austin or the federal, but most likely in Austin, has made a determination that, hey, the way it's owned, it doesn't have to go through the probate process. That's a non-probate asset. And it's going to go automatically to according to the terms of that property, and those are the types of things we're talking about here. And so the most common types of non-probate assets are going to be one, your retirement accounts. These are your IRAs, your 401ks, those types of things that you own, like a Mutual of America, Schwab, right? Like those kinds of accounts, you're going to designate a beneficiary. You're going to go to your financial institution. You're going to say, I'd like to update my beneficiary, and then you're going to list who they are and what percentages they're going to get. Same with your life insurance proceeds. You're going to designate a beneficiary for that, and and then you contact a financial institution that holds the life insurance policy and do it that way. The third type is a payable on death account. Now, this is going to be for your general checking account and your savings account that your daily accounts that you have at either your credit union or your bank, and so those are payable on death accounts. Now, and you will name it designated beneficiary on that. I always like to emphasize to everybody that when you're trying to minimize the need for probate, and by the way, we're not going to be covering probate today. If you have some questions around probate, I cover that a little bit in my first presentation, and we also have a second presentation as part of the kind of trio of topics that we cover in AMOS, which is on clearing title. That presentation has some discussions a little bit on the probate process. So please be sure you watch those or attend those sessions to learn a little bit more about the probate process. But don't be fearful of the probate process. Like sometimes it's what you need to do, and in Texas it's actually pretty straightforward when you have a well-drafted, properly executed will, which is what we're going to be talking about today. But that being said, though, if you can avoid the probate process and it makes sense for your estate to be able to avoid the probate process. One of the things to minimize that need is with the checks and bank accounts, checking and savings accounts with your bank accounts, is through that payable on death account. And so I will tell you, there are so many people, I've had so many people contact who need assistance with a probate, where the only thing they're trying to get access to is the bank account. And so, and for a lot of people, their major assets are their home, their cars, and their bank and their checking accounts, their financial accounts. There are personal account, property and things along that lines, but the things that trigger a need for probate are those three major items. And so when you're able to kind of have a payable on death account with your checking and your savings account, you may be able to avoid the probate process by making sure it is a payable on death account. For all three of those, the ones where you're naming a beneficiary, the when the person passes away, you would contact the financial institution, let them know that the person has passed. They will request a form to be completed by them with whatever form they happen to have, and usually a certified copy of a death certificate. Those will get submitted, and then what will happen after that literally is they will write the check according to the named beneficiaries or transfer it according to whatever the policies are. A 401k and an IRA typically is transferred into another account. A life insurance proceed is typically a check, right? It just kind of depends on what that institution does as they submit that that's the beneficiaries of that. The fourth type of a non-probate asset is a joint tenancy with a right of survivorship. Now, that can exist in different types of things. That can be real property, that can be your checking account. Those are just different types of things. But what happens in a joint tenancy with a right of survivorship is there's an agreement between the people who own the property that says, hey, when the person passes away, when one passes away, the one who survives, the one who's living, is the one who inherits the property. And that's a joint tenancy with a right of survivorship. I always say be really careful about choosing to do that, because it's very hard to undo it once you make your property into a joint tenancy with a right of survivorship. But it's not impossible to do, but something to consider if it makes sense for you and your family. It's important to know that that's not the standard. That is not how property is owned in the state of Texas generally, whether it's separate property or community property. That's a typical misconception or misunderstanding of how property who's owned together in the state of Texas works. So community property, which is the most common one, the surviving spouse does not automatically inherit the property in the state of Texas. It depends on the family dynamics. It depends on whether or not there are children from a previous relationship, if there's any determinations or identifying of how that property is owned during the course of the marriage. And so it's not always guaranteed that the surviving spouse is going to be the surviving heir and the beneficiary of the property according to state law. So don't make those assumptions. And in terms of that, it may be, like, right, depending on the situation, it may be the spouse. It may not be the spouse. But guaranteed 100%, if it's not a spouse, if there's just co-owners, so it's pretty common for siblings to inherit a property and own the property together. The surviving siblings don't get the property if one of them should pass. It'll be the person who passed. Their children will inherit the property unless that property has been made into a joint tenancy with a right of survivorship. So just kind of be aware of that. In all of that aspects around property ownership and how property is going to pass, if you don't have a will, because that's what we're talking about, if you don't have a will, that's something you should probably talk to an attorney about to be sure that you're getting the right advice and making sure that whatever decision making is going to be doing that. Now, that being said, if you take nothing else away from me, you will hear this in every presentation I do. Everybody needs a will. Even me talking about these non-probate assets, and like we're going to talk about transfer on death deeds, we're talking about payable on death accounts, like, ways that we can try to minimize the need for a probate process. It does not mean you don't need a will. No matter what, you need a will. Because it's better to have a will and not need it than to need a will and not have it, because of the complexities and the expense and how difficult it can make a probate process. That is a little bit outside the scope of this presentation, but if nothing else, just know that you need a will. And that will is going to cover everything else. If it's if it's not a non-probate asset, it's a probate asset, right? So everything else that isn't a retirement account, life insurance proceed, payable on death account, or joint tenancy with a right of survivorship will be covered by the will. And so, so that is what we're going to be covering. When you are updating your documents and you're drafting your documents, you always want to be sure that your non-probate assets are also up to date with the correct person that you want to be inheriting the property. Because they don't go through a probate process, whoever is named is going to get the property. So if you have an ex-spouse that's the beneficiary of a life insurance policy, guess who's getting the life insurance policy? Your ex-spouse. So you may want to update that if there's a new spouse, or if you want your children or somebody else to be inheriting that rather than the ex-spouse. So be sure that that also gets updated. All right. Types of wills, just so that you are aware, there's basically in the state of Texas, there's two types of wills. There's a holographic will, which is 100% in your own handwriting. You cannot delegate the writing of a will. So you cannot ask your cousin Susie sitting across the table from you, who has better handwriting, to write that will on your behalf. There is no delegation. It has to be 100% in your own handwriting, signed and dated. It is optional to have two credible witnesses over the age of 14, as well as a self-proving affidavit. We're going to talk about that in a second. The second type of will is an attested will. An attested will is 100% typed will. So you're going to take out your computer, your typewriter, you're going to clickety-clack, type it all out. It's going to get printed out. And that one is signed and dated. It does require two credible witnesses over the age of 14 to witness that will, for that to be a valid will. And then it's optional to have a self-proving affidavit. So first, let's talk about witnessing wills. Whether you have, I always recommend you have witnesses, even if you are using a holographic will, or handwritten will, because witnesses make attending the probate process much easier when you need witnesses. And so it's better to have witnesses if you are able to have them. So when you're executing your will, you're going to sign and date it, but you're going to do that in front of your witnesses. Your witnesses are going to be sitting there. They're going to be watching you sign it. They're going to be aware they're signing a will. So there's no like, hey, yo, I'm getting ready to sign this piece of paper, and they're like sitting in the next room in the living room or getting a cup of coffee, and then they come back and you're like, hey, I need you now to sign this as a witness. That's not a properly executed will, because that witness was not watching you do it, and they weren't aware it was a will when you were signing it. So the requirement is that they have to be aware it's a will that's being signed, and they have to watch the signature happen. And then they're going to sign and date it at the same time. So that is how you witness a will. The option is an option to add what is known as a self-proving affidavit. And this is a separate affidavit. Generally, it can be done together, but for the most part, you're going to see it in the fill in the blank will, that it is a separate affidavit that is signed by you, your witnesses, and a notary. So as you notice, when I talked about executing a will with the witnesses, I didn't say you had to have a notary. Notaries are not required to make a valid will at all. Like all you need is the witnesses for an attested will, the type will, or 100% your own handwriting for a handwritten will. But what a self-proving affidavit does is that it removes the need for the witnesses. So if you are able to do a self-proving affidavit, what happens is that when you're able to go to court with the will, instead of having to call a witness in to come to testify that, yes, Your Honor, that is the person's will, I watched them sign it, execute it, that's their will. The self-proving affidavit allows the executor and the attorney to hand the will over and say, here's a self-proved affidavit. And it's just saying that, and then the court's going to say, okay, witnesses are not required. So it just makes it even more easier. It makes that next step just a little bit less complicated by having a self-proved affidavit. And that one, again, is signed by you, your two witnesses, and a notary. That's also all done at the same time. The witnessing and then the notary is doing it at the same time is the process. Now, we're going to talk about a pro se will next. I just wrote that there's no such thing as a hybrid will, and that is correct. Um, in Texas, the law is pretty clear the way it is written that the will has to either be 100% in your own handwriting or 100% typed. However, there is an exception when it comes to the pro se wills that have been approved by the Texas Supreme Court. In those forms, it does allow for the will to be fill in the blank. Now, I really want to point this out. The law is clear. The wills are supposed to be 100% in your own handwriting or 100% typed. An exception has been made by the Texas Supreme Court in their approved forms. Please do not use another fill in the blank form. There is no indication that I have been able to see in terms of me monitoring that there has been a change in the law that any fill in the blank will is sufficient for this for the courts. The way that the statutes are written, the way the laws are written, it has to be one or the other. And then the Supreme Court has made this exception. So don't go down and Google a will online, print that fill in the blank will, fill that out by hand, and then it's a hybrid, right? Half handwritten because the blanks are handwritten and the rest of the will is typed, and assume that that will is going to be considered a valid will. Again, I have no indication in the things that I have been following up on that indicates that. Now, there could be courts out there that accept them. I just don't have any indication that that's what the wholesale the law is saying that that's okay. So if you're going to use the fill in the blank will, please use the Texas Supreme Court approved forms for that. Now, there's 4 forms that the Supreme Court has approved. It's for a person who is single, widowed, or children who has children, married person who has children, person who is single, widowed, or divorced and who does not have children, and a married person who does not have children. So those are the 4 forms that exist. They have them in both English and in Spanish. So the question is, can I use the form? This is where it's kind of buyer beware. And I don't say this as like, oh, let's hire attorneys or come apply for services because I'm trying to get people to come and see me. But you have to be very careful because in terms of thinking about, does this work for me? This is a standard basic form. It's not going to take into account every individual scenario that can exist. It's not going to take into account nuance and specific needs that might exist for your family. And so you have to think about what that means. Because while a bad will may be okay, right? It's better. I guess it may be better to have a bad will than no will at all. If you're hearing my everyone needs a will thing, but you want the will to be in as good of a shape as possible to try to mitigate and lessen any problems that your executor may be able to have. And so I do recommend that do think about it. Do think about your family dynamics. What's going on there? Is someone estranged? Is there someone that needs to be, um, you know, disinherited? That might be a need that needs to be addressed. It also, there might be, you can laugh. I'm gonna hear people laugh on the other side. Like maybe there's a secret family that people don't want you to know about, right? So, but like you're gonna have to kind of take into account your family members and your dynamics. What's the type of property that's owned? That can have an impact on what's going on there. Who's inheriting? Do they have a special need to be taken into consideration? Adults living with with a disability and they're receiving government benefits based on income. An inheritance can have an impact on that, and so you would want to double check about whether or not the property that they're going to be inheriting under will can impact those benefits. And then all of a sudden you have this unintended consequence of someone not getting a benefit anymore because we just didn't write the will the way it needed to be written to protect that. As a person under a guardianship, that's something to consider. A minor under the age of 18. There's other factors to kind of take into account. So when you do estate planning documents, usually the attorney does ask some questions about who's inheriting and what kind of the realities are as it relates to them. You're going to have to think about the debt that's owed. The because Is there a mortgage or reverse mortgage on the property? Is there a car loan on the property? Not to say that you can't use these forms to be able to do that, but if there's going to be like things that we have to be taking into account as it relates to those properties. Special instructions, as you see when we go through these forms, that there's not really an opportunity to be able to create any kind of special instructions, and special instructions can range in a wide variety of ways. It can be things along the lines of, hey, Susie, help repair my roof. In you know in about 5 years ago, I really think she should be reimbursed for that. And so the first $5,000, the first $10,000 of the sale of the property should go to Susie, and then the remainder should be split among the three children. So that's a special instruction. And so, and that's a pretty basic one. I've seen more complicated ones be requested, but those are types of things that are not going to show up in a basic, try to apply to as many people as possible, fill in the blank form. And so kind of take that into account. I always recommend that if you have the ability to do so, seek out counsel, speak to an attorney, because we are able to see around corners. I always kind of joke that I'm a bad news Jesse kind of person. Like, and that's my job. My job has a lawyer when I'm helping people write their estate planning documents, is to be sure that I am seeing around corners that they're not seeing, to try to mitigate and make the as much as possible the process as easy as I can, because there's been the loss of a loved one. And so I don't want the probate process to be complicated. And so if you have the opportunity, do so. So that way we can be sure that the forms do apply to you if you need to write them yourself. All right, so now we are here to talk about the forms. I am now going to go step by step on these forms. Obviously, there's a lot of information. If you are going to be using these forms to write your own estate planning will, this is a recording. You can go back to our YouTube channel. Ms. Nia is going to send you the link. You can come back and watch this, pause it, re-listen to things that I say. For the most part, it's not complicated, but every once in a while, there's something that's a little bit nuanced, and you may want to come back and watch it again. Just know that this is a reference that's available to you. Do not have to take frantic notes right now. You have access to this recording afterwards, right? So section 1 and by the way, to the extent that the wills look the same among those 4 types of wills, remember I said there's 4 types of wills, I'm not going to make the distinctions, but if there is a distinction, I will mention that. So the first part is the identification of a will. It's going to basically say who you are. Do you have an alternate name? Have you gone by other names, right? And you're going to want to include things like maiden names, or if you have a name change, and to include those things in there as well. You're going to say that basically it's saying that this is your will, that it's revoking any will that you have made beforehand. If you are married, if you're not married, this section will not be in there, but if for the married folks, it will say who you are married to and that they are living and that this is their spouse. And then there's going to be a section to identify, which you can't see on here, but there's going to be a section to identify all of your living children. And so it's just naming who you are and who your family is. Okay. Now, everything I own except for specific gifts. This does sometimes feel like it's a little bit out of order, but this is the way that it is written. So this is on the married form. And so property that you own, separate property plus your half of community property. So remember, in community property, you only own half of it. The other half is owned by your spouse. And so this is saying that this is everything that I own. You will have 2 choices. The first one is the gifted to your spouse. Right, everything to my spouse is basically what you are saying there. If the spouse does not survive me, then divide it equally among all my children, including my deceased children who have children. So what does that mean? If you have 3 children and they're all alive, each of them will receive a third of the estate. If you had 3 children and one of them is passed and they have 2 children that survived them, then 1/3 goes to the 2 surviving children, and 1/3 is shared among the 2 children of this child who passed. So each grandchild will receive 1/6 of the property. So that is what that section is saying. This is probably the most common thing that I see when I draft wills when people are writing who are married, it's very typical to say everything to my spouse in the event of my spouse does not survive, then everything to my children equally, and then if one should predecease, going to their children, their share going to their children. Okay. If you're giving everything to your spouse, then you're going to skip section 3. You're going to go straight to section 4. Okay. Now, option 2 is everything I own, except for a specific gift, right? So this one is for divided equally among all my children, including deceased children who have children. The survival of the spouse does not matter. We are skipping the spouse. That's what's happening in this section. So even though you are married, your spouse is not going to inherit anything under this will. Everything is going to be going to the 3 children or the surviving grandchildren if one of the children should be predeceased. And so that is what that section is. This is also not uncommon. I see this pretty frequently among individuals who have children from a previous marriage. And it's also not uncommon among elderly clients and couples where instead of having the property pass to the spouse, they are just going to automatically pass directly to their children in that respect. So that is also another time where I have seen that option 2 being chosen. Because remember, the surviving spouse is still going to own their half of the community property. All right. And so the section for everything I own except for specific gifts for a single person is you have to name a person, right? So and so that is what happens here. So when you're married, it's identifying that you think it's going to go to your spouse or your children. When you're single, then you're going to have to list the individuals that you want the property to go to. So this is everything I own except for the specific gifts, and you're going to list Bob and Sue there and their names. And of course, if everything goes to them, then you're going to skip the section around the house. And this will be equal though, right? So if you name Bob and Sue, they're going to each receive 50%. There's no percentages here. So remember what I talked about, like that individual document at the beginning, and like this form may not work for you. If you want Sue to get, 60% of the property and Bob to get 40% of the property because, Sue helped you with the roof. You can't do that here. In this one, this is everything I own. So this would not be the place to put that piece of information in. And so now we go to section 3, which is about specific gifts. And it is broken down over 2 items, your house and then your personal property. So the first part is going to be about your house. And there is one option, who's going to get the house. So, right, let's keep track, right? We've identified who we are. In our first section, we have done what is basically a residuary clause, an everything clause, everything to a person. And now we are doing the exceptions. So the first exception, or if you may, is that you want your house to go to whoever is listed here, right? Bob and Susie are now going to inherit the house 50% each. You would list it there. Now, just be aware, people inherit property subject to mortgages and liens. And so if there's a mortgage or a lien on the property, they're going to have to figure out how to pay that. That debt does not go away when a person passes away. If there's a traditional mortgage, they're either going to have to refinance or assume the loan if the finance company will allow them to assume the loan, or they're going to have to pay off the debt. If there's property tax liens on it, they're going to have to pay off that debt. Otherwise, the home will get foreclosed on. And so just be aware that they have to be aware of that. Now, we are going to be talking about a transfer on death deed after we talk about the will. Really important to know that a transfer on death deed has priority over a will, which means that if you prepare a transfer on death deed, you file it in the county court records, and you give the house to Bob and only Bob. If you write Susie and Bob in this section, only Bob gets the property because the transfer on death deed takes priority over the will. So always be aware of that if you want your property to go in a certain way. And a will does not revoke a transfer on death deed either. So if you did that transfer on death deed to Bob 2 years ago, but now you've decided, no, I really want Susie and Bob to split the house equally, I'm going to go ahead and put that in my will. It says it revokes everything. It does not. Bob still gets the house. So if you want to give it to Bob and Susie, then you need to revoke or do a new transfer on death deed. So just always be aware of that when it comes to doing the two pieces of paper or the two documents of advanced planning. All right. So again, we're going on to this exceptions. Everyone gets we have a person who's gotten everything or children who've gotten everything. And now we've excluded the house. The house is going to go someplace. You can leave that blank if you don't want that. If the house is going to go to, surviving spouse or children or whoever was listed in section 2, you don't have to complete that section. Same thing with section 3, except now we're talking about the personal and household items. And so in that first section here, you are going to just list the names of the people. You're going to identify who they are, and in this particular section. What's important to note about what that paragraph is giving the instructions to is it's saying this is who I want to get these personal items, household items, and if they don't survive me, so you give it to Susie, but Susie doesn't survive, then that piece of you give your jewelry to Susie, but Susie doesn't survive, then the jewelry is going to pass according to section 2, because that's section 2 again. I give everything to a person with the exceptions being in section 3. And so that's what that paragraph is saying. But if there's any kind of disagreement about how these personal or household properties are going to be distributed, it's like, well, I'm supposed to get the mugs and I really, but someone's like, no, I was told I was getting the kitchen items and we're not sure what's happening there. The executor will have the final decision-making authority over what happens next. Again, why I talk, it's really important for who you pick for the executor to understand what you would do and do what you would expect, and they would do what you want them to do. And then the next part of that specific gift section is where you're going to list the item and who it's going to get, right? So in section 3 for the personal household items, you've listed the names of the people, right? Who they are. Now you're going to list the item and who is going to get the item. Be sure that the description is clear. You don't want to say the dresser in my bedroom. If you have three dressers, right? You want to be sure that it's clear, right? Like, grandma's diamond earrings. If you have more than one pair of diamond earrings, congratulations. Be sure to know which one is supposed to be going to who, right? So be sure that if there is similar information that you want to be sure that it's descriptive. Also, same with the person. You want to be sure that the name is descriptive. I always make a joke that in my family, there's an awful lot of James and Johns. You can walk into a room, yell James and John, and room with my family, and 2/3 of the men will turn around. And so you have to be sure that you want to put a name down that and makes it clear, right? So if you do have more than one person with a similar name, you're going to identify them as like Bob's kid or cousin Joe or something like that, right? So that way it's clear for the executor to know who that person is. All right, now we're going on to section 4, which is the independent executor section. This is where we're naming that person. That person is going to be in that role of handling your estate. The requirements are they must be 18 years old and the court must approve them. They must be approvable. Generally, the court will approve everybody unless they're disqualified. But for the most part, usually most executors get approved. This section is naming this person to serve as an independent executor. What that means is that the court's not going to supervise the estate. So there's not going to be a court or a judge coming in and saying, hey, how much did you accept for that offer for the house that you're selling? I think I don't agree with that price. I think you should wait and get a higher offer. That the judge is not going to do that. The executor is going to be allowed to do what they need to do without having to keep going back to court for permission or explaining their decision making on what they need to do. As I said, you should be sure you have alternates. In this case, they have up to 2 alternates. You have your first choice, your second, and your third. And it will go in that order. If the first is unable to serve, they will go to the second. If the second's unable to serve, it will go to the third. They don't start at the third and go backwards. Okay. Then after that, it provides all of the general instructions. This is pretty typical standard language that occurs in lots of wills. And so 4.2 is saying that they are going to serve without bond. A bond is basically an insurance policy in its most easy terms. It protects the estate. If there should be any mismanagement, a bond protects the estate. Since you have chosen somebody that you trust and you want them to be able to work independently, not being required to post a bond, which can be pretty expensive, is a good thing to do, and most people do when they list their independent executor. 4.3 is the powers, is what they're allowed to do. It's basically saying, hey, they can administer and handle the estate. That includes paying the debts and selling property if it needs to be done, and that they don't need to have consent from the beneficiaries. This is not a it's not a communal decision on what happens. Executor has been empowered to do what they need to be able to do. The court will not take 4.4 is basically saying the court will not be doing anything other than what is required of them to do by law, which is, as it relates to settling the estate, which is required to provide a notice to the beneficiaries of the estate, and then obtain what is known as the inventory, appraisement, and list of claims owed to the estate. It's basically telling the court what property and debts are the estate has, which is required by law. Section 5 is now where we're going to be dealing with children receiving properties under the will. Minors generally cannot own property on their own. That's kind of a misleading statement. I mean, minors can own some things, but there's rules as it relates to how they can own property when they're under the age of 21. And so this section establishes the custodian who will care for the property until that child turns 21. And so, and you heard that correctly, it is 21, not 18. So if a person is inheriting the property at 16, they will not inherit it until they are 21. If that is something that you want to be done differently, then you would probably not want to use this form for the inheritance for a minor. But those are basically, that's the instructions, right? Anyone under the age of 21 will have a custodian who will take care of that under what is known as the Uniform Transfers and Minor Act of Texas. The custodian will be named by the executor, and that includes, executor can name the surviving parent, and they can have different custodians for different beneficiaries, and the executor themselves can also serve as the custodian if they feel like that's in the best interest of the beneficiary. If you have a minor child in your care or an incapacitated adult, this is typically your children, you will want to name a person to step in as the guardian. So this is naming your choices for the person to serve as a guardian of the person of a minor child or an incapacitated adult child. And you're going to name your first and second choice, and they will go in that order. They will go for the first choice and the second choice. The guardian must be approved by the court, and typically they do try to name the person that's listed, unless that person does not qualify. But it does have to be approved by the court, like the executor. Now we get into section 7, which is, again, some standard legal language that would apply. And so Texas law applies, is what 7.1 says. Everything we're talking about today is about Texas law. If you have property in another state, you're going to have to seek out counsel or information about what is required to handle property in that state. It may or may not be this will in Texas. I don't know. I only practice in Texas. I don't have a license anywhere else. I am not here to give advice on what to do in other states, other than you do need to look at what other states require if property is located there for a probate or transfer of property there. 7.2 is the survivor clause. This is pretty standard. A person needs to survive by 30 days in order to inherit. What does that mean? It means that if a person doesn't survive by 30 days, they will be treated as if though they pre-deceased, that they had passed before the decedent. Why does this matter? People are, sometimes people pass pretty close in time to each other. People are in car accidents. Um, uh, some couples that are, that the spouse may pass pretty quickly afterwards. So there are situations where a person will pass within that time frame, and this avoids a complicated probate scenario where the property gets passed to a beneficiary, and now we have a probate for a second beneficiary. So going back to our example of our children in section 2, so if you have, right, it says it's through my children unless one predeceased. If one of those children should sadly pass 2 weeks after, they will be treated as being predeceased, and then the property will pass according to this will rather than that child's will, and it will go to the children of the child who had passed. And so that is basically what it is saying, is that there's a need to survive for 30 days before they can inherit. The next section is where you're getting ready to execute and do the attestation and the self-proof of the will. Again, I already kind of covered this at the beginning, but let's kind of double check all of this, right? So the witnesses, you're going to sign this. That's your signature, and then your 2 witnesses are going to sign that. Remember, they have to be over the age of 14 and disinterested, not receiving or otherwise will benefit under the will. Receiving a benefit could be a creditor. A creditor would be considered a person who benefits under the will. Right. And then we have the self-proving section of it. So with the notary present, and the instructions are in this will, by the way, so you don't have to remember all of this. And it basically is this attestation, which is, you're signing the will, you're doing this of your free will, and there's witnesses. The witnesses agreed to sign the will, and now you are signing it again. And so now you're going to sign your name here with your date. Oops, I didn't put pictures in there. But so there's a next part, there's a signature block for the witnesses and the notary, and the notary will affix their seal on it. And that is it. That is pretty much the end of the will. And now be aware that not all notaries will execute a will. It's unlikely you can hang on down to the UPS store and ask that notary to execute a will. But just kind of be aware that that happens. Now, that being said, if you decide that you want to do your own will, as part of the AMOS partnership, Miss Nia at the Neighborhood Recovery CDC does have an appointment day where they help everyone execute pro se wills, self-drafted wills. So just be aware that that information is available to you, that resource is available to you. Obviously, it's in Harris County. Anyone who's watching this not in Harris County, you would have to come up with different arrangements if you're not going to be here in Harris County. Right. So what to do next with the will? Once it's been executed and everything like that, staple the will. Once you do that, do not unstaple it. So believe it or not, the process of unstapling a will or taking out the staple can be considered a destruction of the will. And so don't do that. Don't break it apart. If you need to make a copy, you're going to flip each page over. You're not going to take the staple out and run it through a machine. You're going to flip each over, put it on top of the do, and make your photocopies that way. So be sure you don't do that, or you make your photocopies before you staple it. But you're going to be sure once it's stapled, don't unstaple it. Copies are not valid, so be sure that you keep your original in a safe place and let your executor know where that original will is located. Does that include a safety deposit box? Maybe, maybe not. Things you have to be aware of when it comes to a safety deposit box. The person who needs access to it is your executor. They're the ones who have to be able to go and get the document. In order to open a safety deposit box, you must be an account holder and you must have a key. If you are not both, you cannot open up that safety deposit box without a court order. So if you're going to do that, either be sure your executor is on the account and is a key holder, or let the executor know it is in the safety deposit box, and so that way the executor knows to go and contact an attorney who will file a motion with the court for the court to make the order for the bank to open the safety deposit box to be able to obtain the will. Only the executor can obtain the will. So, but otherwise, I always say just keep it in a safe place. Where do you keep your other important documents is probably where you want to keep your will. Where's your social security card? Where are your passports, your birth certificates, right? Typically, those are common important pieces of paper. You keep them in a safe place. They're easy to access if you need to leave in a hurry after a hurricane's coming and you're evacuating, right? Put your will there along with your other advanced planning documents. That's what I typically recommend has the safe place to put it. You don't want it just hanging about. You want to be sure it is secure. You don't want it to be where someone can easily obtain it because obviously there's a lot of personal information in these documents. But otherwise, that's kind of the recommendation. The other thing, I don't have it on here, but also when it comes to the will, don't do anything extra to it. Don't go in and write something else on it. Don't make additional notes, or things along that lines. Again, the process of kind of writing on a will, crossing out names and rewriting things can look like you're voiding out a will. So if you need to change something in your will, you need to do it all over again. You need to do a new will. Don't just go in and be like, oh, I accidentally misspelled Susie's name. Susie spells her name with a Z-Y, not an S-I-E. And so you're going to go in and you're going to cross out the Susie and write, S-U-Z-Y. A court may view that as a voiding of the will and may invalidate that will. So you want to just go ahead and just start over and do it correctly. So just kind of be aware of that. All right, so that's the will. We are now going to move on to the transfer on death deed. Again, just as a reminder, this is a lot of information. For the most part, for a lot of people, that standard will work. Will work for your needs. A lot of people really do have all of their property going to their spouse, everything remaining going to their children. There's not a need for special instructions. No one's living with a disability that requires a concern for their public benefits. There's not a concern about long-term care planning. There's for a lot of people that's going to suffice. But as a reminder, I do really believe that if you have the ability to consult with someone around your estate planning to determine what the right options are for you, I encourage it because, again, we can see around corners that you can't see around or don't know that you need to see around. You may be aware there's a corner there, but you don't know that that's one that affects you. And so I do recommend it. But for the most part, for a lot of people, that standard will be sufficient. The transfer on death deed is up next. This one, unfortunately, is a little confusing. The form itself is not complicated, but it can be confusing with the way that it is written. So a transfer on death deed is commonly known as a TOD for short. It's a way to transfer real property, that's your land and your house, to someone else when the homeowner passes away. It avoids the probate process. Remember what I said earlier, it takes priority over a will because it takes effect immediately upon the person's passing. And so, and just kind of has that reminder for many people, their primary property that they own are their homes, their cars, and their bank accounts. And so for a transfer on death deed, that is how you can pass your home and your land without going through the probate process. Again, you could use a payable on death account to be able to pass your banking accounts without going through the probate process. And while we will not cover this form today, there is a form for your car. There is a designation of a motor vehicle beneficiary form that you can file to be able to transfer your car as well. That form is pretty straightforward and pretty simple. So it would take like 2 minutes to say, complete this part. So, and I do cover that in my other session on what the 2 minutes it takes to complete that form if you wish to use the designation of a motor vehicle beneficiary. You still own the property when you do a transfer on death deed. You can get a mortgage, do repairs, rent, sell, do whatever you like. It's still your house. The house does not belong to the beneficiary until a person passes. You can only convey the portion that you own. So if this is a property that's owned in joint, not in joint tenancy, but in co-tenancy, where it's community property, then you own 50% of the property, and then of course for the co-tenants, the co-owners, it's the applicable percentage that you own. So you cannot give what you don't own. So basically, is what I'm saying there. Again, the property is inherited subject to any debt, and the beneficiary will be responsible for paying any mortgage or lien against that property. The Pro Se Todd form is a toolkit that's been prepared by the Texas Access to Justice Commission. So it's different. That is a different entity from the Supreme Court of Texas. So this is the Texas Access to Justice Commission. They have prepared this form. It is available on texaslawhelp.org. There's also an online form available in that kind of lengthy URL there, but that's interactive where you would go in and type in the information and it will print out the form for you. If you are comfortable using a computer and being online doing that type of an interview, that may be something you should consider. But otherwise, what I will be going through today is the toolkit published by the Texas Access to Justice Commission. It's the same information that you would need for the online form. And so just anytime I talk about like this is what you need to gather, it's going to be the same thing there. All right. So the first section is who owns the property. Now, you do need to list everybody. So even though you're the one making the conveyance, you do need to list everybody here that that's being that owns the property. Okay? It's pretty self-explanatory. The legal description of the property. Now, this one can be complicated. You will need a copy of your existing deed for the legal description. So your warranty deed that you inherited. It is not the physical or mailing address of the property. So if you live on 123 A Street, that's not your legal description. Your legal description usually is they actually look very different depending on the deed and how it was written, how the property was originally conveyed. It could be meets and bounds. It's like type of language. It could be the tract of land from Bob Street till Davis Street, starting at the 35 degrees. They can vary in the way it is described. And so that's why you're going to want to go look at your original deed. If the property was conveyed via a pro se deed, someone who drafted their own deed, like a gift deed, and they didn't use a formal kind of document, you may want to go look at an earlier deed, an earlier warranty deed that may have a little more clear description of the property and make sure that it's accurate. So be sure you're going to want to look at that. It's also not the description on your property tax statement. So your property tax statement does include a legal description, but that is typically shortened to be able to fit the space that is allotted to that description on that form. So don't assume that that is correct. You want to use the original deed that the property was conveyed to. And you're going to write that information in that box. If that's not big enough, then you can add a separate sheet of paper and you can say, see attached document for the legal description. And then number 3 will be the address that is commonly known at the 123 A Street in Houston, 77002, right? So that would be how you complete that. This is the biggest sticking point for a lot of people, getting that legal description to getting that correctly written down. All right, now, please bear with me on these next set of things because there's multiple A's, B's, and C's that we're about to talk about, okay? So we are now dealing with the first set of A, B, and C, right? So there's 3 sections of an A, B, and C. you are going to pick one of them, either that first level of ABCs. You're going to pick you're going to pick whatever one applies to you. So Section A, both spouses own the property and they want to leave the property to the surviving spouse. So that is what Section A is. So you're married, you want the surviving spouse to obtain the property. So that's what it says. That's what number 1 says. Surviving spouse gets the property. Then if there is no surviving spouse, so you are the surviving spouse, then it goes to the alternate beneficiaries who will inherit after both spouses pass, and they will inherit equally. So again, if more than one person is listed, they will get their fair share or their equal share of it. This may or may not be your family member. This is not a requirement. Unlike the will, where it specifically talks about it being children, the transfer on death deed does not. You can list whoever you want at there, and you should list your children if that's who you want to be your alternate beneficiaries. Okay. Now, in this one, it is that the alternate beneficiaries will be the ultimate owners of the property. So upon the passing of the surviving spouse, the alternate beneficiaries are the one who will inherit the property in this scenario, right? Okay, now we're going to Section B. So A is where it's community property. The spouses own the property together. Section B is when one spouse owns the property and wants to leave it to the surviving spouse. So this is separate property. I owned a house prior to getting married to my spouse. It's my separate property. And now the spouse lives in the house that I owned. Who do I want to inherit the house in this particular case? And now you're listing your spouse. So you want your spouse to inherit the property if they survive. If they don't survive, then it will go to the alternate beneficiaries. This is really important to know. If the spouse survives and they inherit the property under provision B1, they own the property. When they pass, it will pass according to their will or their transfer on death deed that they file. Unlike Section A, where the children or whoever is the alternate beneficiaries are named as the ultimate beneficiaries of the transfer on death deed, that's not the case in this. For Section B, the spouse will inherit the property solely if they are the survivor, and the alternate beneficiaries only take if the spouse if the person who drafted this is the surviving spouse and the other spouse had passed before. So, and just like the other, more than one person name, they'll be shared equally. So really important to be aware of what Section B is saying. So if you have children from a previous relationship and you want them to inherit the property and you have a spouse that's not their parent, if you pick Section B, your children will not inherit the property upon the passing of spouse. That's what's happening under Section B. So you're going to look at a different section. You're going to look at Section C is what's going to happen here. So for A and B, we're going to go look at, there's a Section 3, which is the transfer on death, which is the alternate beneficiary who's going to inherit the property in the event that an alternate beneficiary also doesn't survive, right? So we're talking about the primary beneficiary has not survived, and now we're going to the alternate beneficiary is what we're saying is happening, right? So we've listed our spouse, and then we've listed our alternates. What's going to happen if the alternates have also passed, right? So, and then the choices are the deceased alternate beneficiary will inherit, right? So if your alternate beneficiary was your children, then their children will inherit their 50%. That's what 3A is saying there, that their beneficiary will inherit. And or section B is I don't want the survivor to inherit it. Then so the effect of that is that if you have two people who are listed as alternate beneficiaries, right? So you have two children or two individuals that you've listed. One has passed. Section A says property passes to A, to the children of the person who passed. B says if that person passes, I don't want it to go to somebody else, which means that the one alternate beneficiary, the one who survived, inherits 100% of the property. But if both of those alternate beneficiaries should pass, then the transfer on death deed is voided. It's no longer in effect. The property is going to pass according to the will. Call back. Everyone needs the will. This is one of those situations that does apparently show up where all of a sudden we need a will. And if there isn't a will, now we have a complicated probate process to figure out who owns the property, whereas a will would have indicated where that property would go. So that's a little bit confusing. But just kind of be aware of that. I will let you know, most people, you don't have to do this. Like you can choose what's right for you, but most people tend to choose A, right? Because typically alternate beneficiaries tend to be family members and they typically want that portion to pass on to the next generation. But that might not always be the case. But that is what I normally see as being pretty common. Okay. All right. Now we're going to get more complicated. All right. Remember, we have A and B, spouses, alternate beneficiaries. You're going to pick A, community property, surviving spouse goes to alternates on the death of both of spouses. B, separate property goes to spouse in the event that both have predeceased, then to alternates, but otherwise 100% clear to the surviving spouse. If neither one of those is what you want, right? You don't want your property, your community property to go to your spouse and then the alternate, or you don't want your separate property to go to your spouse and then your alternates if both are predeceased. You're gonna pick C or everything else. You're not married, you're a single person and you own a property. Everything else is a C. So C is what you're going to pick if A and B don't apply and you don't want A and B. You're going to pick C. And so this is everything else, right? So C, the first section is you're going to list your primary beneficiary. So, right, you're going to name Bob and Susie here, right? I don't know who Bob and Susie are to us. We don't know if they're cousins, friends, or siblings, children. They're just Bob and Susie, right? Like, so Bob and Susie are each inheriting 50% of the property. I've listed Bob and Susie as my primary beneficiary. And then my alternate beneficiaries are going to be Jim and Sally. All right, so those are going to be my alternate beneficiaries. And so now in this case, just be clear on what's being said here, so you understand what's happening here, is that the alternate beneficiaries only inherit if all of the primary beneficiaries pass before, right? So if Bob and Susie have both passed, then that's when Jim and Sally are going to take. But as long as Bob and or Susie have survived, the alternate beneficiaries don't come into play in this scenario. Now, here's the second set of A, B's, and C's. All right, so that first set of A, B, and C, you're picking one of those sections. For this set of A, B, and C, so this is the A, B, and C under that C, that top level C, we now have another A, B, and C. You need to pick one for each of these. So for each of these, you are completing, right? So first set of A, B, and C, you pick one. The second set of A, B, and C, if you pick C, then for this A, B, and C, you need to pick one or the other for each one of these sections. So and that's going to be kind of what happens to the property on the death of primary beneficiaries and alternate beneficiaries. That's basically what this whole section is basically saying. So the A is if at least one primary beneficiary survives me and they are a child or a sibling, then who's going to get the other half of the property of the deceased primary beneficiary? Does it pass to the children of that one who had passed, or no one else, the surviving beneficiary takes all. So remember, this is very similar to what I just explained in section B, right? So A will be that that portion, that 50% that Susie would have inherited, Susie has passed first, will go to Susie's children. B, Susie has passed, but we don't, section B, but Bob's going to inherit 100% of the property. So that's what section A is saying, when at least one survives. Section B is if no survivor, no primary beneficiary survives me, right? And so both Bob and Susie unfortunately have passed, and we're assuming that they are related, that they are the children or sibling or other descendant of parents, right? There's some kind of family in the immediate family. Then, and all the primary beneficiaries have passed. Where do we want the property to go? A, their children. Bob's children are going to get their 50, Bob's 50%. Susie's children, it's, yeah, Susie is going to get the 50% that Susie belongs, that they get, right? And split equally among them. If Bob happens to have 3 children, they each get a third of the 50%. Susie happens to have 1 child. Susie's child gets 50% of the property, right? And so that's how it's going to be passed on down, okay? Or B, the alternate beneficiaries. I don't want the children of Bob and Susie to get the property. I want Sally and Jim to get the property. So that is what B says, right? So that is going to be A and B. Now C is if the alternate beneficiary does not survive me. So now we're kind of getting into that last bit, right? Like there's, all primary beneficiaries have passed. We don't want the, so now we're looking at alternate beneficiaries and they have also passed. What do we want to happen here? Same thing. A is to their children, Jim and Sally's kids in their equal share. Or B, no one else. That it's going to either go to the survivor of the alternate beneficiaries, or this transfer on death deed no longer exists. Now the property is going to pass according to what the will says. All right. That's it. That is actually the transfer on death deed. It sounds more complicated than it is, but it's only complicated because of the way that it's written, and sometimes the way that the language is, it can be a little confusing on what that means and things along that line. So, but just kind of recap. There's 3 sections, A, B, or C. You're going to pick the A, B, or C. If A and B don't apply to you, you're going to pick C, and then within that C, you're going to pick A, you're going to complete all A, B, and C for all the various scenarios that can happen. So what do you do with the TOD? You must have that notarized. So you will sign it with a notary. Typically, any notary will do that. This one you can take to a UPS store if you want to be able to do that. It's a deed. It's what it is. If there's a co-owner, then it needs to be signed with the co-owner as well. They will obviously sign. The notary will sign and affix the notary seal. You must record the TOD. What does that mean? You must file it in order for it to be valid. This is not one of those documents that a notary can sign and execute and you stick it in your drawer or your safety deposit box, wherever you put it, and be valid. It is not valid unless there's a record in the county clerk records. And that is going to be in the county where the property is located. I am here in Harris County, and my property is located in Harris County. So I would file it there, right? But I happen to live on, the borders of different counties. And so if you live in Fort Bend and that's where your house is, you're going to file it in Fort Bend County, right? So, but be sure it does get filed. There is a filing fee. The cost depends on the county and what they require. And then once you record it, because you're sending in the original with the appropriate payment, the clerk will return the TOD to you. You're going to keep that in the safe place along with your will and other advanced planning documents, as we already discussed. And then that's the record. And then, and typically there is some type of certification of the death that is filed, but it is effective immediately upon death. All right. Then we have our final forms of estate planning. There's quite a few other forms that I did not discuss today on that you have. If you watched my last presentation or even this one, Ms. Nia will send you the templates of these other forms. and you can also complete these on your own. When you see them, you will understand why we didn't spend a lot of time talking about this. They are standard forms, and they're pretty straightforward in terms of what it is. There's not a whole lot to go through to explain like what each section means and things along that lines. The most complicated of these forms is the statutory durable power of attorney. It is worthwhile for you to take some time to understand what each of those powers mean as it relates to what we are talking about. And we're, in those powers, it's like making decisions on rental property and handling your business and things like that, right? So, for a lot of people, giving full authority makes sense and is recommended. But if you do have a little bit more of a complicated situation or individualized situation that you need, then of course I do, again, like everything else, recommend that you speak to an attorney to talk about what each of these powers will mean as it relates to you and the agent that you would be giving this power to. Um, and I do cover pretty in depth what the documents do in the other presentation, but just very quickly, statutory deliverable power of attorney is legal and financial decision making in the event of incapacity. Medical power of attorney is medical decision making in the event of incapacity. An advance directive to physicians is commonly known as a living will. This is in the life decision making in the event of irreversible or terminal condition. A declaration for mental health treatment is a document that identifies what kind of mental health treatment should be made in the event of a psychiatric hospitalization. Um, the other forms are a declaration for a guardian in the event of later incapacity. Should there be a need for court-appointed guardianship to be put into effect, this names the person who would serve as your guardian. This form is so incredibly simple when you see it. A HIPAA release is providing permission for those who are covered by HIPAA, primarily medical providers, but also includes lawyers and others, from sharing private medical information without permission. And then a supported decision-making document is an in-between document for diminishing capacity, where an adult needs some assistance with helping make decisions, but the person here is not making the decision on behalf of the adult. It's just someone who gets called to help make decisions on that. But you'll see that all of these forms are extremely straightforward. There's not a lot to complete in them. It's just really understanding and naming the person and then signing and executing them correctly, which for most of them requires only a notary, with the exception of a declaration for a guardian in the event of later incapacity, which would be executed in the same way as a will with two witnesses and a self-proving affidavit with a notary, if a person is being disqualified from serving as the guardian. I know that's a lot. If you have more questions about those forms, please consider watching the other presentation or coming to my next one, which will be in March, where I will talk about those a little bit more in depth about what they mean and what they do. Okay. And so I thought I saw a question about completing a form and having someone go and take a look at it. Sure. That's something you can do. And if you qualify, now I will let you know, for someone like me at Lone Star Legal Aid, I do need you to still qualify for services before I can even look at the form, to give you any kind of advice on it. But certainly that is certainly something that you can do. There are other possibilities of an attorney being able to go in and answer and doing that for you. But it really kind of honestly depends. Obviously, if you're hiring someone in the private bar, they would probably charge you for it, and they would be like, why don't you just let me draft your documents for you? But that is something that you can do. If you qualify for services, that is something that we can definitely consider. But I will also say the same thing: if you qualify for services, let us draft the documents for you, because we will take care of them for you. And then you'll get the full expansive, catered experience. This is overwhelming. If you're like, Miss Jessie, I'm listening to you, I don't know if these forms apply to me. I'm not sure what to do. I just need some advice. Again, you would have to qualify for services, but we can advise. We can advise you on what's going on in your situation, and you get some sense of what it is, and maybe, it's like, I really would prefer to draft them on my own. I kind of have a need. I really want that security. I don't want to wait for an attorney to help draft them. I still can't afford one. Apply for services. We can definitely advise on what your needs are, and be able to advise if you do need full documents instead of being able to use the pro safe forms for yourself. In addition to Lone Star Legal Aid, as Ms. Nia mentioned at the top, I forgot to add that slide into here. My apologies, but we do have other partners within AMOS, Houston Volunteer Lawyers, as well as the Earl Carl Institute, that all three of us do help with drafting estate planning documents. We also have a partnership with Texas Legal Services Center, which runs Texas Law Help, which is an online website where you can get a lot of information, as well as those interviews that I mentioned for Todd, that you can go through that online interview where you type in the information and it prints it out for you through Texas Law Help. There actually is also links for the statutory forms that I mentioned, so you will be able to do that. Miss Nia, in her email to you, will include all of that information that I forgot to include here. So don't be like, oh my gosh, I don't know how to find them. You will get the contact information for that as well. So just know that there is help available. And if you do want to hire an attorney, there is the Houston Lawyers Referral Service, which is a service of the Houston Bar Association. They are attorneys that you do have to hire and pay, but some of them do offer a sliding scale. I don't know who they are or what they will be. Please don't ask. But that is an option as well if you don't qualify for services and are able to afford an attorney and would like to get that additional help. All right. And with that, I think I'm at the end. I do try to end with a little bit of a funny. And so here's our little comic for the month, which is that Mr. Frosty, it's March. I think it's time to talk estate planning. Poor Frosty. But we know that when his magical hat should reappear, Mr. Frosty will be back next year. So, all right, with that, if anyone has any questions, feel free to unmute yourself and ask, or put it into the chat. If anyone is watching this on the live stream right now, you can add it into the comments on wherever you are. Someone is monitoring that. But as a reminder, this is a very public space. Please do not put anything personal into the chat that people can use against you in the future.
Okay. There was a question that was emailed to me, Jesse. Are revocable living trusts necessary in Texas? If so, how can we have ours reviewed and then modified to meet Texas law?
So, trusts are complicated, and it's going to be outside the scope of really what I can discuss today. I don't recommend anybody writing a trust on their own. There's a lot of unintended mistakes that can happen in a trust that can be difficult to undo, even in a revocable trust. And so I always say, what's the purpose of your trust? It doesn't mean that you don't need a trust in Texas, but I always want to ask, what are you trying to accomplish? Why are we doing a trust? In some states, trusts are what is needed to be able to do estate planning in that state, but that's not quite necessary in the state of Texas. Our probate process is pretty straightforward when you have a well-drafted, properly executed will, which, by the way, the Supreme Court forms, if they meet your needs, is a well-drafted will. It has everything that's needed in there for it to be a properly executed will. And to make the probate process pretty simple, and in fact, depending on the situation, may even be less expensive than going through the process of creating a trust. So if it's about avoiding probate and saving money, a will may be the better choice depending on what you need. But that being said, sometimes trusts are needed. Minors inheriting property, we're talking about special needs, or and things along that lines. You really should speak with an attorney about why you need that trust and what are you trying to accomplish, and then let them draft it for you and create the trust that best serves the needs that you are trying to accomplish. So that's a non-answer. Yes, talk to an attorney. I don't mean to not answer. I don't mean to not answer it, but it is kind of, that is really what it is. It's like, what's the goal? And without going into any kind of details, I really can't answer it. it really needs to be an attorney to really understand what the goals are, and then they're the ones going to be advising on what that trust needs to say.
Okay. And then I had a question as it relates to the Todd. So am I okay? So I know when a couple gets married that they actually only own 50% of their home of the home or their own interest in the home. So when they're completing a Todd, do they have to complete one together? Because at a couple of the other Todd clinics, it was a little confusing with do they have to complete one Todd even though they have separate ownership interests in the same property?
It depends. So that's where it gets a little bit confusing, right? So um if you're completing section A, right, the surviving spouse is the one who's going to be inheriting the property, but on the death of both spouses, then it goes to the children or to the alternate beneficiaries, yes, both of them have to complete that same Todd because they are effectively doing a mirror Todd, so to speak, at that point in that document. But if not, if they're going to be completing section C, then no, they would do their own Todd for their 50% that gets passed. But the couple should talk about that, right? Because you can end up with a very complicated property ownership situation if you did that. So the answer is it depends. If you want to complete section A, then yes, you would do one Todd. Both of them would complete one Todd. If you are looking at section C, then you would each complete one, but highly recommended that y'all chat about it. Maybe potentially, and make sure that we're not ending up in a situation where 8 people own the same property.
Gotcha. And I don't see any other questions in the chat here. But again, if there are any questions that anyone may have, then definitely feel free to kind of chime in. Um, I'm kind of going through the social media and the other questions that were majority of the other questions that were emailed to me in advance. You pretty much answered. One was about the that trust. Um, you already went over the forms, so that was a question. How to avoid probate for a family member, how to establish a will, general information about a will. So there wasn't any other specific questions that were emailed prior to. But do note that again, this session was recorded. It will be emailed out to everyone to go back and take a look at. Also, we're encouraging people to pay it forward, to share the information with as many people as you possibly can, because we know that there's a lot of information, there's a lot of misinformation out there as it relates to wills and estate plans in the state of Texas. And we want to make sure that accurate information is actually kind of getting distributed out there to people, as opposed to these folks listening to the street committee and listening to TikTok and all these other places or whatever, where somebody's telling you what it is that you need to do that has absolutely nothing to do with us here in Texas. So but you have the option of going back and watching the recording, going to the YouTube channel and watching it there. But again, we encourage you to send it out to other people, somebody else that may find this information to be beneficial that was not on the call on the session today. The next Zoom for this particular one, we have this between the wills and the estate advanced legal planning and why do you need it. Jesse alternates that the first Thursday of each month at 1 p.m. So her part one was last month, and I'll include that link for that recording for if you guys want to go back and watch, or and then also give you the schedule for next month as well, so that you can come back. But but this particular segment is always the first Thursday of each month. The next part coming up following this presentation is going to be the probate matters, clearing in inherited property and how to clear title, and deferred property tax options. Like if somebody passes when they've had deferred property taxes, and what do they need to do to get that clear title because they have a tax debt on it. then that presentation is next Thursday. So that one is the second Thursday of each month. So we try to make sure that all the presentations that we do offer, if you guys kind of look at the schedule, you'll see that one thing all kind of relates to another. So if you're interested in homeownership, but you need to get your finances together, there's financial capability that prepares you to become a home buyer. Once you become a home buyer, there's post homeownership education, in protecting your property. You want to do the wills and advanced legal planning. What happens if someone passes away without one? Then you got the clear and title presentation. You find yourself in some kind of financial difficulty. We have the foreclosure presentations. So they're all interrelated somehow or another. So just so that there's kind of like that method to the madness, and one kind of evolves into another. So we do ask for feedback from our participants as well, so that we'll know, like, if other questions kind of come up from these presentations, that we know that there's something else we need to address, then we want to talk about it. We want to elaborate on it. We need to give a little bit more detail about it, because it's too much sometimes to kind of put all into one. But again, that's why we also record the sessions and make sure we send it out to people so they can go back and watch it again, just to kind of get a little bit more explanation. And these sessions are free, so you can feel free to come back as often as you like to actually watch or to participate. Send us questions in advance if you like, but know that there are resources, that we are here. We're trying to be a resource for people in the community. And again, we want to try to get as much out there as we possibly can. So we want everybody to be empowered with the information that they need to make the right decisions for themselves. As Jesse mentioned, they can give advice, but we can't tell you how or what it is that you need to do for yourself and for your family. Only you guys can make that decision. But we just ask that something gets done, especially if COVID taught people nothing else, is that somebody's gonna pass. Everybody's gonna pass at one point or another, but it's just, what do you do to prepare for that moment when it actually happens? So it's no avoiding it. You know there's no way around it. It's going to happen, and not the time nor the place. So better to be prepared, than not be, and find yourselves in a situation during COVID, or when the pandemic did happen, when it first came about. Folks were in the hospital. Nobody could make decisions about anything. Nobody can get access to bank accounts. Nobody could pay bills. Nobody could pay mortgages, because nothing's been put in place. When they pass or what have you, what happens to their children? There was no guardianship that was put in place. So there's those kinds of little things that kind of make you, that start triggering you to start thinking a little bit differently, and trying to be a little bit more prepared. It's like you keep paying for that car insurance, but you never get into an accident. And just as soon as you drop that policy, that's when you get into an accident. It always seems to happen. So if you're not prepared, that's when the thing usually happens. When you are prepared, then we're gonna knock on wood and hope that that's kind of the way that it remains. So we want to encourage everybody to be prepared and be informed. So are there any other questions about anything else that was covered here today? Or if anybody has anything to add? If not, then we are done. Let's see what we got coming up next week. The Harris Central Appraisal District is going to be doing a presentation about the business property tax rendition. Who knew that there was a business property tax that you're supposed to be paying? So for those business owners that are out there, once you start receiving those bills from the appraisal district or from the tax office, then you'll know, like, I didn't know I was supposed to be keeping an inventory of all of my merchandise and paying taxes on it every year, or on your equipment and all this other kinds of stuff. There's all kinds of things, again, that we learn from just having conversations with folks on this presentation. So they're going to be doing that. So we've got Coffee and Conversation that's going to be at the West End Multi-Service Center. Cecile, you still there?
I'm here.
Okay.
Yes,
Do you want to give them a little bit of information about Coffee?
We're going to have coffee. I'm so sorry. Yeah, absolutely. Is my camera? happening here? Okay. Yes. So we are going to be having coffee and conversation at the West End Multi-Service Center next Wednesday from 10 to 12. We have different departments from within the city speaking on issues that affect the neighborhood. We have solid waste coming through. We have the Mayor's Office for People with Disabilities. We also have Lone Star Legal Aid that are going to be there. If you guys need to ask them any questions or sign up for services, they're going to have their team there. Very excited. We'll also have other nonprofit partners coming in, talking about their services and sharing information. Again, that is going to be this upcoming Wednesday, the 12th, from 10 to 12 at the West End Multi-Service Center.
And I'll attach that flyer about the coffee and conversation to the email as well, so that you guys can have that information and to be able to sign up for that. But coffee and conversation is a great opportunity for you to hear from those various department heads that attend. So if you've got questions about something going on in your neighborhood, or if you want to know just, you know, whatever, who do you talk to, who do you direct this particular question or issue to, then that's a great opportunity for you to come in and meet those people or get that issue addressed as well. So, and then again, next Thursday is the clearing title to inherited property presentation and other probate concerns. So that's next Thursday at 1 p.m. as well. So with that being said, thank y'all very much for joining us this afternoon. If you are new to the A Month of Service, we want to welcome you. For those that have been here before, we want to welcome you back and thank you all for your continued support of this collaboration. We hope you all have a wonderful afternoon and remainder of the day. Take care of yourselves and stay safe, and we will see y'all next time.
Thank you, Nia.
All right. Thank you, Ms. Mack.
Thank you very much.
Thank you, Mr. Curry. Appreciate it.